just make sure that our phones are off or are silent.
All rise in court.
Before the Honorable Acting Judge President, Justice Lidwabo, for the Honorable Acting Deputy Judge President Model. In Court 4E, before the Honorable Acting Judge President Lidwabo, before the Honorable Acting Deputy Judge President Model, before the Honorable Madam Justice Quaterel J, the matter of the Government of the Republic of Zambia versus Edgar Lungu and 7 others, case number 096565 of 2025.
May it please you, my lords, my lady, I appear on behalf of the applicant with my learned Junior Marcus.
Court pleases, my lords, my lady, I appear on behalf of the 1st to 7th respondent, along with my learned Junior Advocate Arroyo.
Appear in person. I'm the intervening party. I'm Vincent. I appear in person. Yes.
Vincent
Kafula.
My lords, my lady, yes, that is Mr. Kafula is the intervening party, and perhaps he should start if you would wish to deal with that matter first. May it please you.
Mr. Kafula, when advocates introduced themselves in chambers, we were not there. We discussed with them that we first proceed with your application for the information. We have read your papers. You don't need to repeat what you said on the papers.
Yes.
So we'll give you about 5 minutes to support the application, because it's clear from the papers that the applicants are opposing it.
Yes,
The
sir.
respondents
Okay, my lord. I just want to submit that the applicant has failed to dismiss my application for intervention. The critical question, my lord,
I
that is,
just want us to understand each other.
yes,
You've just said the applicant has failed to dismiss your
my
application.
application for, it's an application to intervene, my lord.
It
So I'm
is the
saying
court that dismisses the application, not the applicant.
there are grounds, my lord. That's what I mean. So the grounds which they have put forward is not sufficient. They are not sufficient enough to dismiss my application to intervene. So the critical question, my lord, which must not be overlooked in this court is, if this court grant an order to force the repatriation of the women of our former late president, and if such order triggers civil unrest in Zambia, how would the rights and safety of Zambians, including myself, be safeguarded? And to answer that, my lord, I'm going to refer you on the supplementary affidavit of the Attorney General at paragraph 14.2, where it is stated. Let me start with 14.3, where they say, nevertheless, under these circumstances, there cannot be any doubt that a failure on the part of the applicant to ensure that the late president be accorded a state funeral to further steer controversy and may lead to civil unrest. So if that violence, my lord, if that violence are to happen, my lord, it means I'm part of it. I'm a Zambian citizen. I need peace. But do we need to force the family of the late president? We don't have to do that, my lord. We have to do that through dialogue. Our political leaders, traditional leaders, and the change.
Sorry for a moment, Mr. Kapula. Please let there be order here. Those who are talking when Mr. Kapula is addressing us and may be forced to say you should move out of it. So please behave yourself. Proceed, Mr. Kapula.
So we don't have to force the family. The family must agree by themselves. No one, this court must not force them to repatriate the remains of their loved ones. The husband can negotiate with them. They can bring neutral parties in a row, like our chiefs, we have the church leaders, our church leaders, and NGOs, people who are not worshiping government. If you bring people who worship government, you can't agree because their negotiation cannot be fair. So we need fair people to negotiate with the family. We can't force them. This court must dismiss the application for the applicant.
But Mr.
I'm going to
Kapula,
give-
so thank you for that. You see, in your application,
Yes, ma'am.
one of the orders that you are seeking is that the body should be repatriated, and you also ask that
Can I just clarify now? I said on the condition of the family, which I mean the family has to decide. I put there on the condition of the family. So the government has no part to force them. The family must agree. If they don't agree, they must find a better way to have them agree, not to force them.
you've made your point.
Thank you. Then, if you go at paragraph 14.2 of the supplemental adjustment of the Attorney General, it is on the bundle K42. He stated this. There is further important consideration. Opposition figures have accused the present government, led by President Ichilema, of ill-treating President Lungu and seeking revenge against him. The government has denied this accusation. I know too. But this is a mere denial. They have admitted that they refused him to go seek medical attention. There is a letter that is disputed. They have agreed in their papers that they stopped him from taking exercises, those health activities, so that he can keep health. They refused him. So, my Lord, the opposition, they are correct. If we force the family, there are many people who are doing. They can cause violence, my Lord. This thing must be solved through dialogue. People must talk. The government are bullying the family. We can't allow such. Why must somebody bully them? They refuse to help them when they needed help. Why must they help now to buy a coffee?
Sorry, can I just ask one thing?
Yes, ma'am.
What is your interest, direct interest in this matter?
The interest is that if the order is granted in favor of the government, the people can arise and can cause trouble, and I'm affected for that. So,
So are you acting on behalf of the people in Zambia, or what is your direct interest?
I'm a Zambian citizen, my Lord. So if there is violence, if there's unrest, you remember we are here in South Africa in 2021 when people they caused that, and you know how many people died, how many businesses which closed, how many billions which are lost. So our country is very small. If they are to do that in my country, even myself, they are affected. So the applicants, they are relying on essay writing for disabled association versus regional grant claims. Where, let me read what the Constitution states. It says, if the applicant shows that he has some right which is affected by the old issue, permission to intervene must be granted. Once the applicant for intervention shows a direct and substantial interest, of the subject matter of the case, the court ought to grant leave to interfere. I submit, my lord, that I have direct and substantial interest in this matter as a Zambian citizen, deeply concerned with potential for civil unrest, as acknowledged by the applicants in their answering affidavit, in their affidavit, supplementary affidavit at paragraph 14.3. The applicant further stated that they further stated that put otherwise absent court intervention, there are no other losses which the applicant is able to make use of which will ensure that Mr. Lungu's body is repatriated back to Zambia. I say, my lord, this is not correct. If they follow a proper dialogue, which neutral people are allowed to.
You've made that submission.
Yes. So they therefore, my lord.
I see that in the application you further seek an order declaring that certain Zambian laws should be declared unconstitutional.
Yes. So now I would like to make a condemnation there, my lord, because I realize that no, this court cannot make that because the Constitution clearly states those things must be done in the Constitutional Court of Zambia, and that.
Do you have further submissions to us regarding the agenda application? You're not arguing the merits now, just assessing your application to join in the proceedings. Do you have further submissions?
No, I have no further submission.
Thank you very much, sir.
May it please you, my lords, my lady, I carefully listened to Mr. Kafula and the sentiments that he expressed. Of course, dialogue is preferable, but that doesn't give him the standing that he purports to argue he has. What we did is we gave notice of a legal point that we will raise, that you find in case lines on section W1, and on W3 what we say is that the applicant in the intervention application never or cannot demonstrate that he has a direct and substantial interest, and he also cannot demonstrate that the application was not made frivolously or that it was made seriously. And to demonstrate the frivolous nature of the application, one only needs to go to the application itself, where the relief that he seeks, there are 9 orders. The 5th order is dismissing the application, and I will deal with that. All the others concern issues that the courts in Zambia clearly has to deal with. Yes. So, if that is conceded, there's simply nothing left but to demonstrate that he has, in fact, no direct and substantial interest. And I only need to take you to the Constitutional Court matter, essay riding for the Disabled Association, where the test is laid down. No doubt, my lords, my lady, you know what the test is: a direct and substantial legal interest that will be affected. And whatever the outcome of this matter may be, none of Mr. Kafula's rights or interests will be affected. He may still approach the courts in Zambia to seek the relief that he says the court should grant and which he considered can't be granted. None of his rights would be affected. So, in the heads of argument, you may have had sight of it. I apologize, it came fairly late in the day, but it is in section ZA, where the heads of argument in the intervention application appear. And I refer to the matter that the intervention applicant relies on. It's the Seguira matter versus Standard Bank, just to illustrate why this application can't succeed. And in the Seguira application or matter, the court granted intervention under circumstances where it concerned the rights of a spouse married in community of property to the joint estate, the communal residence. So what we say is Seguira serves as an example why this application can't succeed. We submit it should be dismissed. The applicant is in person in the heads. We indicated that we would seek costs. We will not assist with that.
Mr. Court, pleases, my lord, my lady, the respondents indicated that it will abide by the court's decision with regard to the intervention application. We don't oppose it, we don't support it. Mr. Court.
The court will attend to some few minutes to consider this application. Proper gents? carefully considered the application by Mr. Kapula, and my colleague will give judgment or a ruling on that application.
The applicant, Mr. Kafula, is asking to be joined or intervened in these proceedings. He has raised or is seeking about 9 orders. He has correctly conceded, and we're thankful for that, that most of those orders this court can't grant, or basically the whole crux of them this court can't grant, because this court cannot intervene in Zambian law. The test for intervention is whether the applicant in this matter has a direct and substantial legal interest in what the order is going to be. We cannot find, because of what the orders he's seeking, that he does have a legal right or interest in what order we will give, and that his rights, legal rights, will be affected. Therefore, the application for intervention is dismissed. No order as to costs.
I agree. I agree.
Wait, please.
In respect of the main application, we have decided that we will give you 15 minutes uninterrupted so that you can just address us, and thereafter you will raise whatever issues that you want to raise.
Thank you, my lord. We prepared a bundle.
Mr. Kapula, you are excused if you want to sit and listen to the proceedings.
My lord Van Heerden, we prepared a bundle for the court's convenience. That's the authorities we refer to in their heads. We handed a copy to our learned friends. What the applicant seek is the deputation of the body of the late president to Zambia, and we contend that the applicant has a clear right. Why is that relevant? Because it's interdictory relief. The clear right we submit are based firstly to an extent on the wishes of the deceased, and we will take you to the founding affidavit where the respondents, in fact, and I may perhaps just clarify when I refer to the respondents, my lords, my lady, I refer to the 1st to 7th respondents. The 8th respondent, who is the undertaker, doesn't play any role. So reference to the respondents essentially is a reference to the family. What they stated is that the deceased, his wish was upon his death, he should be repatriated, but he should be taken by private charter. That's what they say up front. Then there were a number of engagements, and following those, there was a clear agreement reached, and that agreement entailed that the body would be transported, he would be given a state funeral, and it is that agreement that we say provides the clear right that the applicant says exists. What we also now know is that that agreement, which is contested by the respondents, was repudiated. And if that is the case, on the respondents' version, that there is no agreement, we say that the law relating to burial rights in any event affords the applicant the clear right that they seek to put forward. But there is a complicating factor, and that is that what we contend is that there is a foreign element present, and that the Zambian law should apply, considering all the connecting factors, and I will deal with that. And if we look at Zambian law, there is clear judicial precedent stating that in the case of a person of significant national interest, the wishes of that person and even the family of that person must yield to the broader public interest. So what we say, there was an agreement, and in Zambian law that agreement is binding and is enforceable. In the alternative, if there's no agreement, then in any event, the law relating to burial rights provides for the applicant to be able to afford a state funeral and the burial in Lusaka. In the event that the court should find that the South African law should apply, the result would be the same. We say there was an enforceable agreement. We can even spell it out in Latin, pacta sunt servanda. There was clear agreement between the parties that the body should be repatriated. And in South African law, there is also authority to the effect that the court should approach the matter based on fairness, on the circumstances of each case. And in the bundle of authorities that I just handed up to your lordships and my lady, we will also refer to a matter where the court stated, in a case of a customary law marriage.
Just for the sake of clarity, bear with me. The bundle of authority that we handed up, is it also on case line?
But it's been uploaded to case lines, my lord, yes. That in a matter that I will refer your lordships and my lady to, the court found that where it concerned a person, it's a Mr. Tsambo, of significant national interest, or an important person who was being granted a funeral by the province, the court said that the wishes of the family must yield to the broader public interest, which is exactly the same as is the case in Zambia. Those, in broad strokes, are the submissions that the applicant will make. There is also then interlocutory applications that I will deal with. The applicant is aggrieved by what it contends are instances of, let's call it, political grandstanding on the part of the respondent, where they included allegations in the answering affidavit that are vexatious and scandalous. That will be dealt with. There is also then an application for condemnation on the part of the respondents to bring a counter application. We will also briefly deal with that application, which we say simply has no merit and in the interest of justice cannot be granted. If I may...
The respondent also raises, can the government of South Africa just be removed or not? Are you also going to address that, or has that been settled? Would that mean
I would be surprised if the respondents persist with that submission. There was proper notice given that the notice of motion would be amended, 2 paragraphs struck from the founding affidavit. There was no objection raised, and the amendment was properly effected. What we say, my lady, is that the department, DIRCO, so to speak, in colloquial language, has an interest in this matter, clearly, but it is not a legal interest. And it is only for that reason why the department and the minister was cited. And for reasons that I need not dwell on, it was decided to remove the minister from as a party, as a respondent. And the court order clearly gave the minister the right to intervene if the minister felt that it should be heard. It had the opportunity to do so. So I submit that there is no case or question that the department could have been removed, and it is not a case of non-joinder with respect. If I may then turn to the facts, and first start with the wishes of the deceased. What is significant is what the respondents themselves state, and the reference you will find on case lines K18. It is the supplementary founding affidavit, paragraph 7.6. I'm just quickly going to quote from that. 7.6, the family objected that the late President Lungu stated out his wishes before he died, which were that, and firstly, his remains should be repatriated back to Zambia in the same manner that he had travelled to South Africa.
I'm sorry, you've lost me. You referred to K18.
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 And then 7.63, in the event that he was accorded a state funeral, his successor should not be allowed to attend it. Now this comes from the respondents. So the important point is that it was never the late President's wish to be buried in South Africa. That's simply not on the papers. And that's what the respondents now seek to do. So what they want is, in effect, to go contrary and against the wishes of the deceased. What they also said is that in the event that there is a state funeral, his successor should not be allowed to attend it. Now that issue was dealt with specifically in the subsequent meetings that were held between the applicant and the respondents. And it is from those meetings that a compromise agreement flowed. And that compromise agreement, important, entails that if the President is present, he can be there, but he must be there when foreign dignitaries are present and also when the funeral takes place where heads of states are. And I will get to that and I will take you to the relevant portions. So the first important point dealing with the wishes of the late President, there is no indication that he wanted to be buried in South Africa. That's a starting point. Secondly, his wish was to be repatriated. In the founding affidavit, the meetings that were held then are set out. The first one is a meeting on the 10th of June. That was in City Lodge. You find in the supplementary founding affidavit, paragraph 7.9. And the gist of that meeting, I'm just going to summarize to the court. The President would be given a state funeral, and the current President, Hichilema, would not preside over it, but he would be allowed to receive foreign dignitaries. He may be present at the funeral where foreign heads of state would be present, and Archbishop Banda would celebrate the Mass. And then it was also agreed that the tentative order or program would be drawn up and shared. And that program was in fact drawn up. And there's some controversy in the papers. The applicant initially said, we drafted the program. The respondents then retorted and say, no, we drafted the agreement or the program. And
just for me to follow, are you relying on FAA7?
Indeed.
Is that what you're relying on?
That's what I'm now taking the court to, my lord. That program is extremely important for two reasons. Firstly, it was drawn up by the respondents, and secondly, following further negotiations, the parties agreed that that program will be implemented. And what we say is that it is exactly that agreement that we rely on. The agreement that FAA 7 be implemented. And it is that agreement that the respondents breached. If I might ask you to go to FAA 7, it's K64 on case lines. On top of the page, it is stated, Program for Repatriation, Funeral and Burial of the Sixth President, Republican President Dr. Lungu. And then it starts with Wednesday, the 18th of June 2025, departure of the body from the funeral parlor. And then what will happen on that day is also, amongst others, it will be accompanied by military honors. That is after the body now has arrived at Lusaka. There will be military honors. If you go down the page, on Sunday, the 21st of June 2025, provision is then made for the state funeral at Mulungushi Conference Center hosting foreign dignitaries. And your Lordship and my lady will bear in mind that there was the agreement reached that when the funeral takes place, that the current president will be permitted to be there when foreign dignitaries are present to receive them, and also when the state funeral takes place. Now, I emphasize this because this is one of the grounds on which the respondents, when they made the remarkable about turn on the 18th, stated that the agreement was repudiated by the applicant, because they say, no, we've now heard, or we now understand that the president will be present. That was never agreed. We say that is not correct. What is also important, at the bottom of that page, FAA 7, there are 5 notes. The first one, national mourning to be extended. 2, the body always to lay in state at Chifuema. 3, the body to be always accompanied by a relative, the aide-de-camp, and by the doctor, the physician. 4, the parties will consult and agree on who speaks at all events. And 5, the Honourable given Lubinda to speak on behalf of the Patriotic Front Party, who is the current opposition. Nowhere on this document is it stated that the current president may not be present. It's not recorded here. And why not? Because that was not the agreement. The agreement, as I said, was that the president may be present on those conditions that I've set out. So what is important is that following this program, there was again a further meeting that was held, and on the 14th of June 2025, it is now common cause that all the parties agreed on the program which was accepted. I might take you to answering affidavit paragraph 26.1, that is case lines 046. O46 is a very terse statement by the respondents, but extremely significant and important.
Not so fast. I'm not so sure whether the case line page reference number is
My Lord, it's O46.
046.
Yes,
046.
or 046. I think it's a O, capital O. It's paragraph 26.1 of the answering affidavit. I quote, the parties agreed upon the implementation of Annexure FAA 7 on 14 June 2025. And that is the applicant's case. What we say is there was a clear agreement. That agreement was repudiated on the 18th when the respondents refused to cause the body to be transported to Lanseria Airport. And it is that agreement that we seek to enforce, and that gives the applicant the clear right. What is also significant then is that there was a further event.
But perhaps before the further event, my brothers and sisters engage you. If we were to, because 26.1 made reference to Annex FAA7 that you say you rely upon to say that you are disagreeing. You will recall that Annex FAA7 makes a reference to the arrival of dignitaries. Do you say that this is the context within which the current head of state would participate to receive foreign guests?
That is a submission, and that is the consequence.
Is that not the norm?
That would be what one would expect, especially when military honors is provided, that the current president, as head of the military, head of the armed forces, would be present. What the respondents contend is, look, we did not understand it in that manner. We say that is an untenable proposition. And especially if you view this in the context of the earlier agreement, where the respondents contended, where the respondents agreed that yes, the current president may be present when the foreign dignitaries are there, and in the funeral when the heads of state are present, that clearly would be the position, my lord.
Is it not raising a dispute of fact?
I submit no, my lord. What they say, on the papers before the court, there was an agreement. We say we rely on that agreement. They say, properly interpreted, that agreement gives rise to further or to a different conclusion. That's a matter of law, the interpretation of the agreement. And we say that there is simply no basis to contend that such an interpretation is possible. So, with respect, there is no dispute as far as facts are concerned. There may be a dispute as far as the law is concerned. And we're comfortable to say that the agreement is clear and properly interpreted. The applicant should be entitled to have the body repatriated for purposes of a state funeral. That's been the clear agreement. And that's also, and that is the next step, my lord, what the respondents conceded when there was the joint press conference on the 15th. And the content of, or what the respondents during that press conference did was to candidly concede what they themselves described as a compromise agreement. And the spokesperson for the family, it's a Mr. Zulu, he stated, he set out the terms of that agreement. And you find it in the supplementary affidavit, paragraph 9.5, it's case lines K24. So, paragraph 9.5, and I'm not going to read the entire dialogue, but what the applicant says is that the seventh respondent set out the compromise agreement that was reached. Number one, that the body of the late president shall be transported together with the family from Lanseria using a private charter. Secondly, following arrival and receipt of the body by the family, full military honors will be conducted at the Kenneth Kaunda International Airport, after which the body shall be taken to the funeral house. Paragraph 4, that the state funeral that will host foreign dignitaries shall be held at the Mulungushi Conference Center. And it goes on. 7, the body of the late president shall always be accompanied by a relative, the aide-de-camp, and former president's personal physician. So what the respondents Mr. Zulu was always the spokesperson for the family. What they confirmed is that Annex FAA 7 would be implemented, and that is what we say what should happen. And then sadly the respondents turned around and reneged on that agreement, which their spokesperson clearly articulated.
Mr. Makis, they invite me to that annex, please.
K64.
Somewhere at the bottom, I think talks about that there will be further communications.
Yes.
Well, now that is there not an indication? It says that parties should consult and agree on who speaks all things.
Yes.
Now the fact that an agreement has not been reached on this, it is not an indication that the parties have not yet fully agreed about how the former president should develop.
My Lord, what the agreement says is that you will consult. Whether that would be enforceable by a court, that may be open to debate. And there is no allegation that the respondent or that the applicant would not be prepared to consult. So what the respondent said is that no, the President would preside over the proceedings, and they also indicated that they want to a private church service or a church service upon arrival to take place, and that they say was never agreed. Those are the two grounds on which they say the applicant repudiated. And what we say,
The fact that there was no agreement as to whether the president would decide or not, is that not an indication that the parties have not reached an agreement about how the criminal is sentenced?
what we say, my Lord, is that FAA 7 is the agreement. How you should implement it, that is the second question, and that's probably what your Lordship is asking. Does this agreement entail that the President would preside? What we say is, if you look at this agreement in its totality and the role that the President would play, there will be military honors where he will be present.
I understand other things that are in that form. That's not an issue. Was there an agreement on the role that was played by the president?
We say yes, because FAA 7 must be seen in the context, and that context is provided by the negotiations that preceded it, that clearly spelled out and set out the role that the President will play.
You say item 4 on this amendment should be not.
Item 4, that says the parties will consult.
And agree on who speaks and all the rest. An agreement reached on the aspect.
Well, the parties agreed that there will be consultation. And the way I understand the law, my Lord, is that such an agreement, it's a pactum de contrahendo, so to speak. If they can't reach agreement on who should speak, there's no deadlock breaking mechanism. So this particular provision may be problematic. But my submission is it does not negate the entire agreement that has been reached. So even if there's an agreement to consult,
So there is an agreement to consult. And the way I understand the papers, this issue of whether the president will take part or not was not agreed upon.
that's the respondent's version, my Lord.
So the applicant's version is that they agreed upon.
Yes, it was agreed.
Not a dispute of fact.
It was agreed that he would be present upon the arrival of the dignitaries and when the funeral take place, when the foreign heads of state would be present. But this issue that the parties will consult, that's the agreement. If the respondent says no, there was no agreement that the president may preside, we don't have an issue with that, as long as FAA 7 is implemented. That's what we say. So interpret FAA 7, and if you look at FAA 7, that's what the applicant seeks in the notice of motion, implementation of that.
Perhaps as a follow-up for my benefit, what is meant by presiding in this context? Won't there be a program director?
Well,
does it mean that the current president will be presiding over the program? Is that what is meant by presiding?
my lord, I can only take it as far as what the paper says.
Perhaps the draft program might give us a clue. The draft program that was prepared after the agreement that we have done on FAA 7 might give us a clue. Is there a reference to who is presiding in that draft? That, or rather, does it contradict the contents of FAA 7?
My lord, I checked it and I couldn't find any contradiction.
You could not find it?
No. Let's just go to the draft. That is the one that was disputed.
Archbishop found listed on the program, that was the news for the
Yes, it's page 0101. The handwritten one that was also sent on the same day.
What is the case number?
0101.
So 0101, as I understand, is common clause, is that right?
Yes, it's this EL16, my lord. I just need to find the reference in the answering affidavit. Yes, it's a bit difficult to read, my lord.
This is a draft, it's not a document the parties have
No, this is, yes, it comes from the applicant, and my understanding is that this is why the applicants now say, look, the respondents say there was a breach. And this serial 2, I'm just reading from the document itself. Upon arrival at Mulungushi, Old Wing, the President of the Republic of Zambia will receive the family and the military will march the casket into the hall and position the casket in readiness for body viewing. Now that's not, who will say, in other words, that's not an indication that he will do a speech or will state anything. The way I understand this is just he will be present. And that appears to be the entire complaint of the respondents. Because the current president will be there, that goes against the grain of the agreement. And that's why they say there was a repudiation. Now this ties up clearly with the military will be present, the president will be there, and he will receive the casket. So I'm afraid I can't see any contradiction between what this document says and what the agreed program also stipulates. So to conclude on the agreement itself, what we say is that the relief we seek is based on this agreement, and the issue that bothers the court, the question of the consultation and the fact that there may not be an agreement on who exactly will speak. What we say is the agreement provides for a consultative process.
It's who's presiding, because that is in the center of the dispute.
Well, who will preside? As far as the funeral is concerned, it's clear that the Archbishop will preside. When the body arrives, the President will be there. He's head of state. He's the head of the military. He will clearly be in a position there to represent the state of Zambia, the Republic. And if you call that preside, then yes, he will preside. What we say is there will be military honors. And if the conclusion is that the head of state will preside, then that is a conclusion that will flow logically from that fact. It will not mean that the applicant has breached the agreement, because this is what it is really all about. If we then move on, the respondents contend there was no agreement. We deny that. We say there was clearly an agreement. Then we say the law in respect of burial rights apply. And if you then ask the question, what law should be applied? We say that the conflict rules will take you to the laws of Zambia. And that we deal with in the heads of argument. Paragraphs 3.6 to 3.8. Well, firstly, 3.4. Why do we say there is a foreign element? Is because this matter concerns the body of the late President of the Republic of Zambia. The family are Zambian citizens, Zambian nationals. The late President was domiciled in Zambia. He was only temporarily in South Africa. And what we say is, or what LAWSA says, is that if there's a foreign element, a court must go through various steps. And the first is the characterization, and that is to identify the dispute. The dispute here is clear. It concerns the burial rights of the state in our context, or the family. And then if you characterize the matter, then you should look at the connecting factors. And what we say is that the law of the jurisdiction that has the closest and most real connection with the case is Zambian law.
On 3.5 of your case, you correctly states that dealing with these issues, there are other factors to consider, mutual resilience, and other aspect that you mentioned here is the place where transaction takes place. You agree that there is transaction took place in South Africa?
Yes.
And why should South African law?
My lord, that's a complicated or a complex issue, because it may be that the law of Zambia would say, look, in an event such as this, you must look at the law of the contract, the place where the contract took place, the lex loci contractus. And the principle, I did not refer to it in my head, so the principle is the principle of renvoi. But what we say is that the law that has the clearest and most real connection is Zambian law. But yes, the court may decide to deal with the matter on the basis that the parties contracted in South Africa, the lex loci contractus should apply, and if you do that, then clearly the result would be South African law, and then the contentions that we have already made as far as breach is concerned would apply. Incidentally, the position in Zambian law is exactly the same as in South African law as far as the law of contract is concerned. In the heads I gave you a reference to an eminent writer on the law of contract. And what is also necessary just to briefly point out is that, and I see in the respondent's answering affidavit, or in the heads of argument, it is stated that the applicants did not produce any expert evidence as far as the Zambian law is concerned, but that is not correct. The supplementary founding affidavit makes it clear that the Attorney General who deposed to the founding affidavit is an expert. He's the government's chief legal advisor. He has various law degrees. He's a practitioner. He confirms the position in Zambian law. And then there's also a further expert, Mr. Mutemwa, who is State Counsel. That is the equivalent of the Senior Counsel in South Africa. He's also an expert in Zambian law, and he also confirms that the position in Zambian law is as is set out in the supplementary founding affidavit.
What I need clarity on is that since this foreign law, the court may consider, and if we consider South African law, also look at the constitution of the country regarding the dignity of life and freedom of rights.
Yes.
Now, if we focus, or if we decide to consider South African law, should the rights of respondents be given more?
What we say is, if you look at South African law and you look at the right of the respondents, you should look at it in totality, and that will take me to the matter that I want to refer you to. But if I may perhaps just finish with the Zambian law and the law relating to burial rights. And it won't take me long, my lord. It is that matter of the People versus Secretary of Cabinet, ex parte Kaweche Kaunda. And you will find the relevant portion on K126, where the Zambian High Court stated yes.
The decision is clear that the distinguishing factor is in that case, President Kaunda was in Zambia.
Yes.
And the distinguishing factor is in this case, as we call it, is in South Africa.
Indeed.
But we can
Yes.
proceed.
Yes. Apart from that distinction, the facts are almost on all fours. Because in this matter, the family wanted a private burial, not at Embassy Park. They wanted the court to respect what they also contended were the wishes of the late President Kaunda. And the court then found, firstly, there is no empirical evidence deduced in relation to the wish of the first president, that's President Kaunda. Now, I may pause in this matter what we do have is that the President said, I want to be repatriated. So if you can just bear that in the back of your minds. Then a state funeral is, my firm understanding, is a public funeral ceremony observing strict rules of protocol held to honor the people of national significance. And then the important conclusion is bottom of the page. A state funeral must stand as such from beginning to end, and I do verily believe that even if I were to hold that it was a personal wish of the deceased, this in my view is one case which must demonstrate that public interest overrides personal interest.
And is that not so because it's a president or a late president?
Indeed.
That places a different stance on the matter.
And, indeed, and this is exactly what we have in front of the court today. And if we look at the South African law, and that is the two matters, or that there are two matters that I did not refer to in my heads of argument. And these matters are, well, it's actually one matter. It's the matter of Sengadi versus Sambo. It is item number 13 in the bundle that we handed up, and that was also in case lines T104. 13.
On the list of authorities, you have Gabama and Betty.
13. No, on the index it's matter number 13, my lord. Yes, it should be T104. This is a decision from the Gauteng local division. Mokgatleng J, His Lordship, granted that decision. And what this matter was all about, it concerned an application by the customary law wife to have the deceased buried at a place where they wanted to arrange for the burial. And that application was opposed by Mr. Tsambo, who is the father of the deceased and the father-in-law of the applicant. And the issue in that was raised was whether there was in fact a valid customary law marriage. And the contention was that the wife was not properly handed over to the husband's family. And the learned judge then found that that may be so. She may not have been properly handed over, but that provision in the customary law of marriage is unconstitutional. And he then found that because that requirement falls to be disregarded, there was in fact a valid marriage. His conclusion then is that, well, if that is so, the wife's wishes as far as burial must take precedent. But then comes an important part of that judgment, paragraph 41. You will find that on probably T.
110.
Yes, 110. I'm quoting from the decision. The applicant, as the customary law wife of the deceased, Jabulani Tsambu, pursuant to a customary law marriage concluded between himself and the deceased on so-and-so date, is entitled to bury her customary law marriage husband, the deceased. But in this matter, there are competing claims predicated on the principle of Ubuntu vis-à-vis the deceased's family and the applicant's rights as the deceased customary law widow. The considerations of public, the principle of fairness, equality, equity, and the interest of justice, and the balance of convenience, and the exigency that the deceased was a public figure of national importance and was to be accorded a civil funeral by the provincial government of the Northwest, which was funding the costs of the funeral burial of the deceased at the community hall, which was already booked. That as this urgent application was being argued, a second service was being held. And then the learned judge continues, paragraph 42. These multiple competing and practical considerations cannot be governed and resolved strictly on the basis of the principles governing the granting of interdict at this late hour, to interdict the respondent from the respondent, that's the husband and the provincial government, from proceeding with the funeral and the deceased. The court was obliged to exercise a practical common sense approach, which prompted the court to subsume the legitimate burial rights of the applicant as the customary law wife of the deceased to the greater, equally competing rights of the public interests and the deceased's family rights, more especially where the deceased body was lying in state in Mahikeng and so forth. So what we say is that there is already clear judicial precedent in this province and in the local division for an approach that we contend should be adopted. And in our heads of argument, we referred you to the two matters, the two decisions by Fleming, Mr. Justice Fleming, the Trollop and the Kutuane matter, where he also propagated and advocated a more flexible approach, taking into consideration all the circumstances. Now, I also need to point out to the court that that decision or those decisions were criticized.
Just want to pay the fee for another 15 minutes to address this to
I will comfortably make it. Those decisions, the Kutuane and the Trollop decisions, were criticized in the PN and another versus PN matter. It's referred to by the respondents in their heads of argument, and it's also, it should be, it's item 15. Item 15T128. And in the PN matter, the learned judge, Mr. Justice Moshoane, criticized the approach adopted by the court in that matter. It's in paragraph 25 of that decision. And what the learned judge pointed out is that, look, you can't just ignore the rights of the common law wife in a common law marriage. And if you want to, if a court wants to develop the common law, then the court, it should be done properly. But what I should just point out is that the court in the PN and PN matter was seized with principles relating to the burial rights of customary law that flow from a customary law marriage. In the Trollop and Kutuane matter, the judge dealt with civil law marriages, and he referred to Foot. And what Foot said would apply in the case of a burial, and what the learned judge pointed out is that Foot is more concerned with the duty to bury. In other words, not to let the body decay, not to let the body unburied. And what the learned judge said is that Foot did not concern or did not consider the right, who has the right to bury, and especially what would be the position when there is or when there are competing or conflicting claims, such as what we have here. And it is in that context that the court in Trollop and also in the second matter, the Kutuane matter, concluded that the court should adopt a flexible approach and look at all the circumstances. And what we say is those circumstances, as was the case in the Sengadi versus Sambo matter, resounding conclusion would be the government or the applicant should be entitled to bury, for the very reason that the late president was not an ordinary person. I might point out that the Sambo matter, Sengadi versus Sambo, it went on appeal to the SCA, and the SCA dismissed the appeal, but for a different reason. What the SCA found was that the court could not have, of own accord, concluded that the rule, or the customary law rule, to hand over the wife was unconstitutional. The matter was never raised on the papers. But the Supreme Court of Appeal then found that on the facts, there was in fact a marriage. And it reached the same conclusion as the quota quo, but via a different route. But the SCA never criticized the finding of the quota quo in paragraphs 41 and 42. As I indicated or said, it dismissed the appeal. So what we say is that the principle in the Sengadi matter would accord with what was also found to be the proper approach by His Lordship Mr. Justice Fleming in the other two matters that I refer to. And it is also clear from that decision by His Lordship Justice Fleming that there is a difference of approach between what he referred to as the old Transvaal province and the position in the southern jurisdictions, in the Transkei and Eastern Cape, where they give preference to the rights of the surviving spouse or the heirs. And we contend that the approach by Fleming and also in Sengadi should be followed and should be adopted. That concludes my address to you on the merits. I just need now to deal with the condonation application and then the application to strike out. Dealing with the condonation first. What the respondents seek to do is to introduce a counter application at a late hour, late in the day, so to speak. And the counter application is peculiar because what they seek to do is they want to introduce, and they say that they do it on the basis of the facts already put before court in the answering affidavit, is to declare the agreement, which we have now indicated has its basis in FAA 7, to declare it void based on a misrepresentation, fraudulent, alternatively negligent. And then they also say, well, there are two further grounds on which we seek to impugn or have the agreement be declared invalid, and that is firstly because it is impossible to fulfill, and secondly because it will grow or cause undue hardship. And in the answering affidavit to that counter application, what the applicants simply say is that there are no facts provided to support any of those contentions. But taking a step back, when you seek an indulgence, condonation, you need to fully explain your delay, you need to fully explain the full period, set out the reasons, and provide the court with a reasonable explanation. And what we say is that the respondent simply woefully failed to do that. They never particularize when they concluded the counter application should be brought. it is not clear on the papers what consultations they did. There are broad and generalized statements made that we consulted, and then we came to the conclusion that we should, that we will file the answering affidavit, but they don't say what happened thereafter. It was on the 11th of June. So what we say is that an applicant for condonation should show good cause. It has two legs: a reasonable explanation, which we say is lacking. The second leg is that the application is not frivolous and it has prospects of success, and we say there are simply none because no facts are provided. The Constitutional Court says that ultimately it must be in the interest of justice, and we say under the circumstances that you have before you, interest of justice will never be served by granting condonation, which will lead to postponement of the matter. It will require further consultations, and that can simply not be permitted. The respondent or the applicant dealt with these issues in the heads of argument. It is ZA, section ZA 02-6, where the heads of argument start, and we also refer you to the decision of the Constitutional Court. It is in the Van Wyk matter, Van Wyk versus Unitas Hospital. Those principles are well established, what the Constitutional Court says an applicant for condonation should satisfy. So we say that there is no basis for the granting of condonation, and it falls to be dismissed with costs. I will deal with the issue of costs just before I sit down. Then your Lordship has, and my lady has, the striking out application. What the applicant says is that there are portions of the answering affidavit that are vexatious and scandalous, that serve only one purpose, and that is to paint the current president with a tar brush, and that is completely irrelevant to the matter at hand. Those allegations, because they are unsubstantiated, no facts were provided, we say we can't answer thereto. So that's where the prejudice lies. And in the supplementary founding affidavit, those instances are listed, and I do not intend to go through and to read out each and every one of these offending portions. What I may just point out is by way of summary, it is in the heads of argument, paragraph 6.6. The offending portions are dealt with in 6.6.1 up to 6.6.16. So those are all instances of what we say is nothing more than political grandstanding and attempts to vex, and these allegations fall to be struck out. They are scandalous in the sense used by the Constitutional Court.
So I really am begging to find that there is any prejudice to the argument. If it is accepted, I'll just give one example that the authorities refused the late president to travel to attend a conference. The authorities refused him permission to come to South Africa, as documented by the letters. So if they say that might well contributed to his early demise, where lies the prejudice? They are giving context.
Well, my Lord, that particular allegation, if my memory serves, we do not seek to strike. What we do seek to strike is where there are references to persecution, that the president fled Zambia. Those allegations, we say, have no place here because they are simply not the truth. Well, there are no facts to back them up. And that's why we say they must be struck. Paragraph 3.8 of the answering affidavit. The words flagrant abuse of human rights. But human rights were abused. It's not particularized. Those instances that they say he was refused permission to go to a church on one instance. He was refused to leave the country because he did not provide medical records in another. Are these instances of flagrant human abuse? Clearly not. So what are these? And that's why we say we are prejudiced.
Why should it offend the applicant if there's a suggestion that he was compelled to seek financial support from family and friends against the background that his pension was withdrawn, his pension benefit was withdrawn? What is offending about it?
It is tied up with 3.13, my lord. It says, this pattern of targeting the family members of political opponents, and then it ends with that sentence. Perhaps I can just go there, because you need to read these in context, in the broader context. So what they say is that there was a concerted effort on the part of the applicant to persecute. That's what they say, and that's what we say the applicant is prejudiced by. 3.13, if I may just go there. Yes, this pattern of targeting the family members of political opponents constitutes a blatant abuse of power and a violation of both domestic and international legal standards. These are serious allegations made against the government of the Republic of Zambia, and there are simply no facts given in support of it. How does the applicant even start to address this? And that's why we say we are prejudiced. We can't simply deny this. The facts or the allegations are made. We can say it's not the truth, which we do, but these allegations should not have found their way into the answering affidavit in the first place. And that is why we also object to that first statement that we seek to have struck out. It's because it's part of this entire narrative. 3.14, further example of these underhanded tactics. Well, 3.14 is what we say is irrelevant. Yes, 3.14 to 3.16. So if I may deal with that, 3.14 to 16 deals with firstly what happened.
Even if that is true, how will it affect our judgment?
It can't.
No, it can't.
It can't, my lady. But that also takes me to the relevance of those statements. These are serious allegations made that simply has no relevance to the matter at hand. And on that basis, the applicant is also entitled to have it struck. And the last item that I need to just quickly deal with is the impermissible hearsay, and that is an equally serious allegation that concerns the fact that because on the respondent's version, I paused to mention, I interrupted myself. What the respondent says is because you refused permission, you caused the early demise of the late president. And they state it here. I paused to mention that the treating physicians expressly indicated that had the late President Lungu been afforded the opportunity to consult with them during 2023 or at latest early 24, they would in all probability have been able to remove the tumor timeously thereby avoiding any life-threatening consequences. Now, this is again a very serious allegation that they make. It will not affect the judgment, no. But so it's irrelevant, firstly. But secondly, this comes from the mouth of the treating physicians. It's not confirmed, and it's the serious allegation that is made that simply depends on. You can't touch any weight with it, my lord. But what we say, it should be struck. We're entitled to have it struck. It is irrelevant. It is impermissible hearsay, and we seek an order to that effect. My lords, my lady, that concludes the address. We seek costs, scale C, including cost of legal counsel. Striking out the normal cost is a punitive order. We seek a punitive order if you strike. May it please you.
Thank you very much. First of all, Jane, for 15 minutes.
As the court pleases, my lord, yes. Thank you, my lords and my lady. I'll prepare and proceed with my argument in the same sequence as my learned senior friend. It might help a little bit to keep track of the arguments as well, and under the same headings for those purposes. But the first thing that we must remember here, and that this court must take into consideration, is that we're actually dealing with an ordinary citizen of Zambia, and who was now in South Africa when he passed away. And that's made clear in the letter that was sent when his benefits were withdrawn, my lord and my lady, and that's EL 10 on the 30th of October 2023. The late president, for all intents and purposes, according to the applicant, became an ordinary citizen. His office was taken away, his salary was taken away, all of his pensions was taken away. Now, it's ingenious for the applicants to now allege, only when there's an urgent application before this court, to say, no, it's now all back. After his passing, we're giving him back all his benefits, my lord. That can never be, and that's also not what the Benefits Act states. That was not taken any further by my learned friend, but I submit the Benefits Act does not make provision for the reinstatement, at least not after the death of the late president, and in any event, it only refers to benefits that he would have gotten, nothing that he must take or ought to have taken, or that can be enforced upon him. Then we get to the first argument of the applicant that was raised here before court, and that is we must look at the wishes of the deceased. And that would be wonderful, and it would be great, and I would appeal to everyone to make a proper will, and this might serve as a good reminder to do that. But this court cannot find that the late president wanted to be buried in Zambia. In support of that argument, my lords, the paragraph in the founding affidavit is paragraph 7.6 that's relied upon. Now, if one reads paragraph 7.6 of the founding...
Just before you proceed, so in second item, your colleague able to invite us as we go along?
As the court pleases, yes. It will be on page K18, and she will refer the Honourable Court to page K18, K18. I see she's just having trouble with connection at this stage. Sorry for that. So, paragraph 7.6, we need to read that. It says the family objected that the late President Lungu stated out his wishes before he died, which were that. So, on their own version, the family objected that those are his wishes that's listed there. So they cannot rely on paragraph 7.6, it's not what it says. In any event, one then needs to read the answering affidavit in response to that, and that's at page 045, where it says at paragraph 7.10, where it says it's admitted that there was a second meeting held. It's denied that the current president would preside over the state funeral. It was proposed that the current president only be allowed to receive foreign dignitaries and could be present at the funeral where foreign heads of state would be present. The current president was not to play any further role in the burial proceedings.
Sorry, please repeat the paragraph you read from?
It's paragraph 24 on page 045 in the answering affidavit. Taking.
But does it say that they object to the body going to Zambia?
It does not say it objects. It does not say it wants to. The body needs to go back, or that was his wish. As the court pleases, my lady.
I apologize.
No, my lady.
Asking the question.
I understand. But the effect thereof is, and taking into account Plascon Evans, is this court cannot make a finding on what is the late president's wishes. Does he want to go back, or does he want to stay here when he passed away? So that question cannot be answered by this court on the papers before it. What was the wishes of the late president? And that argument then falls flat for the applicant to say, but his wishes was that he needs to go back. He's repatriated. Then it leaves them with the second argument of a pleaded agreement. Now, the pleaded agreement we find on paragraph 7.10 of the founding papers. K19. Case lines, page K19. They say, on the 10th of June, so they fixed the date and time of this agreement. We must know when there's consensus, when there's a meeting of mind, if you want to plead the agreement. Waterfalls, the delegation went with the representatives. The 7th respondent again acted as the family spokesperson, and substantial progress was made during this meeting. The following was agreed. So they fixed the point there of the agreement, the purported agreement. And then they list the terms there, which they then say, one of them was 7.10.4, the President of Zambia would preside over the state funeral, and the Catholic Archbishop, Dr. Alec Banda, would celebrate the Mass. Now, we go to the answering affidavit, and we see that that's denied that 7.10.4 would ever be a term of that agreement. It's denied, expressly denied in the answering affidavit. And taking a contextual approach to the matter of pleading the agreement, we know why it's denied because of the treatment of the late president. We can understand why he would deny this. Taking into account all the issues that he had with the current president and all the instances where his freedom was taken away, all the criminal matters that were brought against his family, we can understand why that is a pertinent material fact that the family will not budge on. And then we need to compare FAA 7 with EL 16, because FAA 7 is the one that was referred to in the founding affidavit incorrectly, that was prepared by the applicants. That one was prepared, in fact, by the respondent. And then in the replying affidavit, they agreed that that was a mistake. It was prepared by the respondents, the typed version. And that's the version when this court correctly found that, but it's not a final version of an agreement, because even at the bottom it says parties will consult and agree on who speaks.
I'm sorry to interrupt. There was no finding. We made no finding.
Oh, comment, sorry, as the court pleases, my lord, incorrect referencing. But where there was a comment that says parties will consult and agree on who speaks at all events. Clearly, it's not finalized. All those issues in FAA 7. One then sees the proposed agreement that was handed to the respondent, EL 16, which differs from FAA 7. So FAA 7 would be the version of the respondents, and EL 16 at that stage would be the version of the applicant. Now, if those two don't coincide, there's definitely no meeting of minds, and there's no consensus. There can never be. There's objective proof that it can never be. So EL 16 specifically says, at that second paragraph, upon arrival, I can't make out that word, but the old wing, the President of the Republic of Zambia will receive the family and the military as much in the conflict. And then there's a further paragraph, subparagraph A, the President of the Republic of South Africa, Zambia, will lay the wretch on the proceedings. And then they differentiate between dignitaries and the President by visiting by all dignitaries, but they differentiate in A, in that subparagraph, between the President and dignitaries. So you cannot even take it that dignitaries just simply includes the President. This is their version. They make the differentiation between dignitaries and the President. Now,
Just one moment, please.
let's go, please. It should be the end of the case, as the court pleases, my lord. No, my lord, it should be the end of the case, but I'll get to all of their arguments and deal with all of their arguments. With the law of burial rights, which was the further point they raised, and the conflict rule, and they say we should take the law of Zambia to be applied here. So the Lex Fori, it seems to be common cause. We're in the forum of Pretoria. They chose the court here. No issue about the forum. So the Lex Causa, there's an issue about. Based on that, they refer to the characterization test. And they say because there's only one foreign element, and that is that the deceased is a Zambian national, this court does not have jurisdiction. There is one element that they can rely on, that's common cause. All of the other elements and connecting factors brings them back actually to South Africa. And those connecting factors is, if you look at a part delicta, the delict, if you want to call it a delict, was transpired in South Africa. The death transpired here. If you look at the interdict, they're seeking a South African interdict to be enforced in a South African country. The wishes of the deceased family, with all due respect, the Lex Causa, if they want to rely on agreement, all of that was reached in South Africa. The connecting factors doesn't favour the applicant to apply the Zambian law, with all due respect. If one wants to even maybe look at the Zambian law, again, I need to play devil's advocate here and deal with everything. The Kahunda matter doesn't take it further for the applicant. It's a review, doesn't go into the merits of the application. That's clearly stated in that judgment. It dealt with a current or late president in Zambia who did receive his benefits and was not a normal citizen. So the Kahuna matter doesn't really help them, with all due respect. It's differentiatable to the matters before the court now.
What about the reasoning of the court? What the court did that mean?
Well, the public interest was because it's the actually it's the late president.
We have a list.
No, we do not, my lord, with all due respect.
Is this not a late president?
If he was treated as a late president, he would not. We would not have these issues, with all due respect. His benefits and everything was taken away from him. He is a former president,
so
yes. With regards to how he was treated, he wants nothing to do with the current president. And that is completely understandable, taking the context of this matter. If I were to have, or any person to have, and it's not about who's right or wrong, it's to see the context here. I have any gripe with my brother, and I do not want him to preside over my funeral. It's my wish. And those wishes, this court will give effect to. Like I say, rightly or wrongly, doesn't matter. Practicalities aside, doesn't matter. The wish of the deceased is that the current president must not be there. And in fact, he said it on numerous occasions. There's podcasts, there's his own words about how he was treated, and one can understand that he doesn't want the current president to preside over his funeral.
Mr. Doctor, can you clarify me on this point? Should this court consider the wish of the deceased or the wish of the wife and the family?
If the wish of the deceased can be ascertained about where to be buried, this court needs to enforce it. If it can't be, you look at, according to South African law, and even the cases my learned senior friend refers to Sengadi and the like, all of those cases in South Africa, you look at the deceased, does he have a will, does he say where he wants to be buried? If he doesn't, if we can't make that call, then we look at his wife, basically. If it's now his customary wife or civil wife, we need to find out who's his wife in terms of all of those decisions, and we look at it, and then maybe the next of kin, the siblings and the like. Those are how I see the case law in South Africa.
What is the wish of the deceased? Where would the deceased want to be buried?
Well, we cannot say where he wants to be buried, my lord, so I cannot make that submission.
The wife?
The wife wants him to be buried here.
Was there no arrangements that he should be taken to Zambia to...
There were certain negotiations shortly after his death about whether or not to bury him in Zambia or not. All of those negotiations, offers, counter offers, all fall flat. And there's no agreement to it. wish as it stands here, as contained in the answering affidavit, is that he be buried here. As a court leader. And if one wants to say there is some type of Zambian law that needs to be applied, all of that still needs to pass constitutional muster. It must not infringe any decision of this court. Ultimately, must not. We're dealing here with a very personal right of the burial issues of any person. And the court cannot, or the applicant cannot, infringe on the following rights. Section 10, the dignity of the deceased. Section 15, the freedom of religion. 30 and 31, the rights of cultural practices. Section 12(2)(b), security and control over one's body, which includes the deceased's body. This court ultimately must find, whatever the decision is, that it does not infringe on these rights. So even if Zambian law is to be applied, it needs to be tested against the Constitution. And that's those rights that are now presented to the court.
And how would it infringe the cultural rights?
Well, the cultural rights, in all of the matters, my lady, and even in some of those Zambian matters that's been referred to by our learned friend, is the family's wishes is pretty much pertinent and of paramount importance.
So that's the only thing you're referring to?
With regards to the...
Cultural rights.
Yes. And in this instance, the dignity of the deceased, he made it very clear that it would be against his wishes and, according to him, undignified to be buried when the current president is presiding over his funeral. Again, no question about if it's right or wrong. It is his wishes. Then, my lady, I'll deal with the... See, I still have a few minutes. My lord, I'll deal with the conditional counter application and specifically the condemnation that is being objected to. See, condemnation is in essence being sought for a period of 5-6 days roughly, which I would submit is not a great degree of lateness, taking into account the following: the type of application and time periods that the parties had to comply with, the very real situation that everybody wants finality to these proceedings, and in the interest of justice, I would submit that those the facts and the pleadings, because the affidavit must contain the facts and the pleading, therefore we had to file the conditional counter application to align our pleadings with the facts. Something the applicant chose not to do any further with regards to what type of relief they sought. They sought a declarative. They didn't seek specific performance in prayer one then. So we needed to align everything to make sure that everything's before court, everything is properly ventilated. The facts that we rely on, which the applicant says is non-existent in that affidavit, is existent. We rely on all the facts already stated, the representation, the impossibility that they admit to say if there's a breach, it's not material, and in any event, it's impossible to agree to such a term because the president will be there. And then obviously the undue hardship has already been dealt with. It will be undignified to force the respondents to have the current president preside over the funeral of the late president.
Sorry, are you saying we must read those factors in?
Those factors are dealt with because we incorporate the factors of the answering affidavit in the counter application. We start off by saying everything that's said in the answering affidavit is applicable. The reason why the conditional counter application was filed is to bring into a conditional counter claim, which is just the prayers need to align with all the facts. So we're saying there's no agreement, but we're saying, for argument's sake, if the court might find there's some sort of agreement, we need to plead in the notice of motion, in the counter application, that it is impossible to enforce that agreement that they then suppose or present to the court as the agreement. We then need to say that there's undue hardship and that specific performance under these conditions can never be granted because it is subject to the Constitution and the rights of the family. And therefore,
What are the facts for this conditional counter?
in the answering affidavit and in the affidavit itself,
So we must go and look for it in the application for
No, no, my lady, no.
We must go and look for facts in the answering that.
No, my lady, we say what the representation is. The representation is that they would stick to AA7 and they did not. That is the representation that was
So
made.
now you say AA7
Well,
is a binding contract because they had to stick to it.
in the alternative, my lady, if this court finds there's some sort of agreement, I'm entitled to plead the alternative to say that that agreement, if it is found to be there, which we deny, is in fact there was a material misrepresentation about the facts of that agreement. And clearly there is. The parties aren't speaking about the same thing in those negotiations. Then we say further alternatively, even if this court might find that there is not a material misrepresentation, then it's impossible to enforce the agreement as pleaded by the applicant, because the late president will always be there once the body is repatriated. And they say as much in the replying affidavit. They do not say he will not preside over the funeral.
Nobody seems to be upset that the president will be there, as long as he doesn't play an active role.
My lady, reading the replying affidavit of the applicant, he's going to play an active role. They're saying they don't care about this. If the body is there, it is going to happen. They say it's impossible for him not to participate in the funeral. The replying affidavit.
But a concession was made earlier in submission that the country insists that he should preside, if I understood Mr. Counsel for the applicant correctly.
No, he should not resign. That's paragraph 7.6, which was clearly denied in the answering affidavit. Even paragraph 7.6 in the founding affidavit doesn't say what was submitted to the court. It's the paragraph 7.6 of the founding affidavit, I think, what my lord is referring to.
My lord, what I intended to convey was that there may be a difference of interpretation. What does the word preside mean? And what we say is that if you look at what the president would do, he would be present when the military honors take place. He will be present when the funeral service is that's presided over by Bishop Banda, when that takes place, because he will receive the foreign heads of state. If that means he will preside, yes, then he presides. So it's an interpretation issue. They understand what they contend is that he shouldn't be there and he shouldn't use the word preside. What we say is he will do what FAA 7 says. That's what he will do. Nothing more, nothing less. May it please you, Lord.
As the court pleases, I've made the submissions on the conditional counterclaim. I don't know if there's any questions on that part. With regards to the striking out application of the applicants against certain portions of the answering affidavit, I'll be very quick. I do submit that at the very least, it's not really necessary to decide if it's vexatious or scandalous or irrelevant. They haven't showed any prejudice in those matter being before court. With all due respect, it also doesn't really make sense, because in that application they're blowing hot and cold. They seek to take out certain portions, but there are a lot of other portions that set out the facts in any event and deals with how the late president was treated by the current president. So in any event, the striking out application doesn't make a lot of sense, because it still leaves in most of the evidence.
But those are facts that they could answer to.
My lady, I could answer to all the facts with all due respect. So when we say he was refused medical treatment, and we attach a letter to the paper showing that he could not leave Zambia, they could say then obviously this is the reason for that. When he was refused to go to church, it's a factual event which they can answer to. Was he refused to go to church? If he was refused, what's the reason for that? Did they stop him from jogging? Is it true? And what's the reason for that? Did they open several criminal cases against his family? Is it true? Is there good reason for that? All of that they can answer to. There's no reason not to answer to it. The reason why it's in the application is not because it's irrelevant. It's to give context to this court in interpreting what the situation is between the parties and understanding the position of the respondent and why they feel so strongly about the material term of the current president not having to do anything with the burial. So I would submit the striking application should be dismissed with cost, the same cost as what I'll argue, or it should be cost in the court. With regards to the respondent's striking out application, there are certain passages in the replying affidavit that wants to, and stated as a fact, which is all hearsay, that the President wanted to be buried in Zambia. And I've listed those paragraphs. There's no evidence showing that he wanted to be buried in Zambia, and they cannot make that submission to the court, and this court can never find such a fact exists. Wherefore, those parts in our striking application is all hearsay and irrelevant and should be struck from the replying affidavit with all due respect. The last issue, which I will not belabor, I'll just submit, and the submission is already made in my heads of argument with regards to the ex parte order that was made by this court by the variation of the original court order and the conduct of the attorney for the applicant. The papers make it clear that she was aware of certain facts which she did not convey to the court. And under those circumstances, that instance needs to be referred to the LPC for further investigation. It should not transpire that any officer of this court, as court pleases, my lord.
Has that been done?
It is in our
Complaint in,
no complaint has formally yet been lodged. We are a bit busy with this, but I take my lord's word. As the court pleases, like I say, I'm not going to take it further than what is said in the heads of argument. Then with regards to cost, we deal with cost also quite comprehensively in our heads of argument and set out the reasons why costs should be awarded on an attorney-client scale in favour of the respondents. If it's not on an attorney-client scale, I would submit that cost on a scale C would be appropriate, including obviously a cost of the employment of two counsel. The reason being the very serious nature of the application, that the respondent was forced to abandon a burial that was already planned, money already spent. It caused great embarrassment to the respondent and the family to having to cancel that burial on a very, very short notice. The original application, they say in the urgent application that they got notice on the 18th of June that the body will not be repatriated back to Zambia. That's correct. Then they ought to have brought it already on the 20th and not wait until the 25th on the day of the burial to bring such an application. It's an abuse of process and caused great distress, especially to the widow of the late president, and embarrassment because everybody was already sitting and present at the burial that was arranged for the 25th of June. Further than that, we see, and I submit, that the founding affidavit does not support the relief that the applicant's contending for. It's seeking a declarator, but in fact it seems to be more relying on an agreement. They're not pleading specific performance at all. They're not seeking really specific performance in the notice of motion at all. They would never be entitled to a declarator that they're seeking because the case is really about an agreement. A declarator is something else with different requirements. That's the court pleases, my lord. That's all for the respondents. I just want to...
Given the nature of this matter, parties sit down, try to reach an equitable solution.
My lord.
So, I'm not yet done. There were costs that were incurred by the respondents and the funeral. So, wouldn't it be appropriate that the cost should make an order in this private case on costs?
My lord, it's a very novel application. I understand what my lord's conveying, that it might be an option for this court under the circumstances dealing with the burial rights, and that there's not really, it seems, pertinent case law on this point yet. It is probably a little bit novel. I can't take it further than that, except to say the respondent should not be out of pocket for trying to...
Somehow, it might be there's a concession by the government that they should get benefits, should get a house, vehicle, and so on.
Well, my lord, unfortunately...
The pension going forward.
My lord, unfortunately, I'm not in a position to say what's happening in Zambia and why, or anything at all with regard to let's call it undertakings, and whether they'll be kept or not kept, and I'm not going to venture into those grounds.
No, but my main question is, would it be appropriate for this court to make such an order?
About benefits then?
No, that
What?
each party should be liable for its own costs in this application.
My Lord, I don't think it would be appropriate. I don't think the respondent needs to be out of pocket, with all due respect, but I understand that it's a novel point.
Still, ready to reply?
15 minutes, my Lord. Firstly, I must just start with a correction. The Kutuane matter, I submitted or stated that that matter dealt with a civil law marriage. It's not correct. This is a pre-constitutional matter. It was heard on the 14th of August 1992. So it deals with a customary law marriage, but it was argued on the basis of the common law foot, Van Leeuwen and those authorities. And it's in that context that the judge made those remarks. There's another matter that I just need to also draw your attention to. It's the matter of MT and MC, MT versus MC and Faith Funeral Home. We will upload the reference on case lines. It's the case number. It's a decision by Adams J, Mr. Justice Adams in the South Gauteng High Court. And in that matter also, he came to the conclusion that where there are multiple competing and practical considerations or multiple competing claims, these cannot be ignored and cannot be governed and resolved strictly on the basis of the principles according to the granting of interdicts. The court is obliged to adopt a practical common sense approach. So what the court here did was exactly what the court did in the Tambo and the matter that I referred to.
Which case would that be?
It is this case of.
Refresh my memory. I know I went to it, but I can't remember.
It's MT and MC versus Faith Funeral Home. My Lord, I don't know if it is in the bundle. It's not in this bundle. It's either referred to by my learned friend or it was referred to in the matters that were quoted. So we will upload a copy of this decision. But it certainly also lends support to a more equitable approach or more common sense approach, and especially in this type of matter. Firstly, starting with the submission, which I found rather extraordinary, that the late president was an ordinary Zambian. That is simply preposterous. But that argument it's grounded on the provisions of the Benefits Act. And the applicant, through the mouth of the Attorney General, says the Benefit Act is clear that the benefits are just suspended for so long as you engage in active politics. Upon his death, that impediment or the reason for the suspension falls away and the benefits become payable. One of the benefits is funeral costs. And what the Attorney General says is this is the way the Act should be interpreted, which is in the realm of, obviously, your Lordships and my lady can read the Act. The Attorney General confirms that a sensible interpretation is the interpretation that the applicant attaches to it.
Are we getting an assurance that person now in Zambia is running in favor of the widow?
It will. It must. That's what the Act says. She will get a house. I think she gets a car. Children get benefits. Those will follow. It's in the papers. Then
the concession, maybe not to how the actually interpretation is something else. The concession that is made.
Based on the papers, my Lord, yes. The first point, the question of the wishes of the deceased, what my learned friend did, there's a fancy word to it. If you look at the line and your eye jumps to another point, there's an explanation for that. Your Lordship, or the court referred, my learned friend, to what is stated as far as the wishes of the deceased are concerned, and that is in paragraph 7.6. The family objected that the late president stated his wishes. My learned friend said, no, but that's denied. And then he referred the court to paragraph, the answering affidavit, paragraph 19.1 on 044. But if you look at 044, paragraph 19.1, no, sorry, my learned friend referred to paragraph 24. He said, it is denied that the president would preside over a state funeral. It was proposed that the current president only be allowed to receive from the... So his answer to was that, were those the wishes of the president? He said, no, look at what he stated in 24.2. But that deals with an entirely different paragraph. That deals with 7.10. We are busy dealing with 7.6. 7.6 sets out the wishes of the family, or the late president, and that is dealt with in 19.1 on 044. And there the respondent says, the proposed conditions of my family are stated herein. From the listed conditions, it is clear that the family would not agree to the current president playing any role in the burial of the late President Lungu. So they don't take issue with the fact that on their version, those were the wishes of the late president. So the submission that there is no evidence as to his wishes is wrong. It is as we say in the supplementary founding affidavit, paragraph 7.6. It's not denied. Then the second point that my learned friend forcefully argued, there was no agreement. What he never referred to is what is in paragraph 9.5. 9.5 of the supplementary founding affidavit on page K24. 9.5 reads, the seventh respondent, Mr. Zulu, set out the compromise agreement that was reached. My learned friend didn't deal with that because he can't. On the family's own version, there was an agreement. So they can't turn around and argue and make submissions contrary to what is common cause on the papers. Mr. Zulu set out, number one, will be repatriated. I'm not going to go through. So my submission is simply that contention that there was no agreement is untenable. That takes me to the Plascon Evans rule that was at times, see, it's one of the deck chairs that just went, my lord. The Plascon Evans rule, yes, that rule does apply, but the court also is entitled to adopt a robust approach. A line of cases, Sofiantini versus Mold, and especially in circumstances such as the present, where we sit, the court has to deal on an urgent basis. It needs to adopt that common sense approach advocated in those line of cases that go back many, many decades, and tells the court how it should deal with if there are disputes, or fact, which I contend there are not. Then the question of the defective notice of motion, it came as a bit of a surprise to me. What the applicant, how the notice of motion is structured, is a declarator declaring the right of the applicant to have the body repatriated, coupled with an interdict that the sheriff would be entitled to cause the transport of the body, and that declaratory relief is squarely grounded on the clear right that the applicant says exists. So the contention that the notice of motion is somewhat flawed, somehow flawed, I submit can't hold any water. Then the question or the issues with the counter application, the impossibility and the hardship, those are defenses clearly. You don't raise a counter application, you don't bring a counter application to put that before a court. You simply argue, you sort of put the facts and you argue on the facts. If the agreement can't be implemented, if it's impossible, there's no counterclaim that you need to bring. It's when you deal with misrepresentation and the right to resile from the contract, that clearly is on a different plane. There you would need a counter application. I must correct myself, not even. There is authority to the effect that you can raise that as a defense as well, the right to cancel. So it all turns on the merits. In other words, if there are there prospects of success, we say there are no, because the facts are missing, and in any event, there is no satisfactory explanation. The last issue, the question of striking out that the respondents seek, insofar as the allegations in the in the reply are concerned. I'm not going to read through those, my lord and my lady. If you read through the allegations that the applicants seek to strike, they are clearly not hearsay. For example, where the Attorney General says, based on the evidence, that's one example that comes to mind. Based on the evidence, it is clear that a certain conclusion must follow. They want that strike. They said it's hearsay. That's clearly not hearsay by any stretch of the imagination. That leaves me with costs. My lords, my ladies, the court indicated that an equitable approach, costs always has that component, maybe not to make an order of costs as to costs. We will obviously not object if you exercise your discretion in that manner. But what we say is ordinarily we would be entitled to costs, and we would also be entitled to the costs of the urgent application. That was because the applicant found out on the 23rd that the funeral will take place on the 25th. It had no choice but to rush to court to interdict the proceedings, and we say that if there's a cost order, the applicant should also be granted the cost of that proceeding, or that process.
About the conduct of the applicant in approaching this court on an ex parte basis, as in fact the matter that was already caused.
Yes.
Is that something that we need to look at?
My lord, what happened there? Yes. What happened there is that there was some debate between the parties as to the interpretation of the court order, and the applicant invited the respondent to state its interpretation of the order, which was...
Made by agreement, we should keep that in mind.
Yes, yes. What the applicant said is that our understanding, taking into consideration the context of that order, is that the body will stay with the undertaker and you can't remove it. And the reason why that debate ensued was because the applicant obtained information that there may be an attempt to move the body. And when the respondent then said, no, we're not in agreement, that's not how the order should be interpreted, the applicant approached the court on the basis that the order was granted in the common, or on the common understanding that the body will not be moved. Because it will not make sense if these proceedings would proceed, and in the interim the respondents can simply move the body, bury it, to whatever this proceedings set out to prevent. Now the respondents complain and say no, but the attorney misled the court. That is simply presumptuous, and if they proceed with a complaint, they're obviously welcome to do so. That complaint will be dealt with, no doubt, accordingly. So, my lord, you may consider the ex parte application. If I'm correct, we don't see costs as far as that is concerned. My learned junior can check. I don't think. Yes. So those costs shouldn't play a role, and you can take it into account, certainly. My pleasure.
Thank you very much,
Sample submissions made by our council. We hope it will make our task, this difficult task, a bit easier to deal with. We are also alive that there is an urgent matter that needs that judgment should be delivered quickly. The undertaking that this court can make is that they will ensure that judgment is delivered not later than Friday. It may be tomorrow, but not later than Friday.
May I please?
And those ladies, court agents.